Hello, I'm Jessica Ryan Keeney. I am a family law attorney. I'm licensed to practice law in the state of California. I am the Department of Child Support Services attorney for two small Northern California counties. I'm a former city attorney for just under 5 years. What I'm about to say today is not legal advice. It is for educational purposes only. If you have any questions or comments, go ahead, put them in the comments below. Any answers will not be legal advice, but they make for good discussions. And sometimes they make an appearance as an entire video. Go ahead, like the video, subscribe, ding the bell so that you get notifications when we upload new content. And you may see my son make a cameo or two in this video. He's in the office with me. You may also hear him making some noises in the background. Sorry, there's not a whole lot I can do about it. This video discusses reconciling with the parent of your children, living with that parent and your children, and the effect it has on a child support order during that period. So for purposes of this discussion, the following timeline happened. Mother and father lived together but were not married, and they had kids together. Mother and father separated and did not live together. Mother got a child support order against father while they were separated. Mother and father reconciled and lived together with the children. Father did not pay child support during this time. Mother and father separated again and quit living together. Mother started receiving cash aid for the children, and DCSS opened a child support case against father. DCSS is now trying to collect child support arrears for the time mother and father were reconciled and living together. And the question is, can DCSS do this? So the quick answer is that when there's child support order, regardless of if it's the result of a divorce case or a parentage case, and regardless of if it's a temporary order or a permanent order, when the parties reconcile and live together with the children, that child support order is terminated, and that comes from the language of the family code. If an action is later brought against the parent ordered to pay child support, that parent should be prepared to present evidence to the court that he satisfied his parental obligation by providing for the children during the reconciliation, and the court should not allow child support to be collected for the time that mother and father reconciled and were living together with the children. Providing for the children during the reconciliation is also known as in-kind support or in-the-home support. And so during the period mom and dad lived together, if dad was providing in-kind or in-the-home support, basically providing for the daily needs of the children, DCSS or mom will not be allowed to collect child support for that time that mom and dad were reconciled. So now let's dive in. Or I should say reconciled and living with the children. So let's dive in. Let's look at what the statutes and the California Code of Regulations and the case law has to say about all this. In relevant part, Family Code Section 3602 reads as follows. Unless the order specifies otherwise, an order made pursuant to this chapter is not enforceable during any period in which the parties have reconciled and are living together. And by the way, I'll have citations for the law and the case law that I cite in the description below. So this section applies during the pendency of child support proceedings because it's in the chapter called Spousal and Child Support During Pendency of Proceedings, but it's clear that unless the child support order states otherwise, it's not enforceable when the parties are reconciled and living together. And then case law makes it so that this section of the family code applies during, even when child support orders are not pending, when the case isn't pending, when there's already been an order made. So in relevant part, 22 California Code of Regulations Section 118203 discusses how DCSS deals with reconciliation, and in relevant part it reads as follows. Each local child support agency shall establish and use a system for closing for Title 4D cases and shall close any case when it meets at least one of the following case closure criteria. There is no longer, this is the section that's relevant, there's no longer a current support order and no arrearage payments were made in the preceding 12 consecutive months, and assigned and unassigned arrears total less than $500 or arrears are unenforceable under state law. Situations in which this criteria apply include but are not limited to the following, and then it says reconciliation of the family. So California Code of Regulations specifically contemplates families reconciling and DCSS closing their case under certain circumstances. Now, it's important to realize that there's a difference between DCSS closing their case and a child support order being set to zero. The court has to set the order to zero. Just because DCSS closes the case doesn't mean the order is set to zero. But in this situation that we're discussing here, Dad's not wanting child support to be collected for the period that he was living with the children and mom, and that's understandable because he was providing for the children during that time period. Now, it would be nice and clean if Dad got child support set to zero during this time, but the case law recognizes that this can be a particularly difficult time to get child support set to zero, and that'll come up as I'm reading quotes from the case law. So what does the case law have to say about this? Well, I've picked out the case of Helgestad and Vargas, and this is an important case when it comes to this topic. This is a case in which mother and father were never married and had 2 children. They separated, agreed to a parentage judgment that established that father is the father of the children, a parenting plan with mother having primary physical custody and father having visitation, as well as the amount of child support father was to pay mother each month. At some point after the judgment was entered, mother and father reconciled. Father moved in with mother and the children. While living with mother and the children, father paid rent to mother's father, who owned the building. And of important note, mother had not been paying rent to her father. It only happened when father moved in that father had to pay rent to mother's father. The reconciliation lasted about 9 months and father moved back out. While mother and father were reconciled, father did not pay child support. After moving out, father asked the court to determine his arrears. The trial court concluded that father, his name was, he was the appellant and his name was George Vargas, was not eligible for any such Jackson credits because this case did not fit the Jackson pattern of child support order that originated in a divorce proceeding, and also because there was not a total reversal of custody, but rather a period of cohabitation or shared custody in the context of an attempted reconciliation. And father appealed that decision. So the court reversed the decision of the trial court because the court believed the same equitable considerations that apply to support orders arising out of marital cases should also apply to support orders arising out of paternity cases. We, being the court, see no reason to differentiate total changes of custody from periods of living together in the same household. Actual support is actual support. The court further held, we therefore conclude the trial court erred in ruling George, or father, was categorically ineligible for Jackson credits. The case must be remanded to give the court the opportunity to consider George's request for them. And for the benefit of the court on remand, we provide 1 point of guidance. And the guidance the court gave the trial court is as follows. The essence of the equitable credit approach is that in the home support during a period of living with the children can count against an ongoing support order that is framed only in monetary terms. And this is Dalton v. Dalton and Child Support Enforcement Administration v. Shehan. And the actual sites will be in the description below, and they'll be in the article on my webpage. However, we must also point out that under the equitable credit approach, the payer spouse necessarily has the burden of showing the provision of actual in-kind or in-the-home support. So this is where I come to the conclusion that in this situation, the party owing support needs to be able to show the court, needs to be prepared to show the court that they actually provided for the daily needs of the children while they were reconciled and living with the children. So the court agreed with the trial court's determination that father did not get credit for paying rent to mother's father when he moved in with mother and the children because mother was not previously paying rent. Therefore, paying rent was not providing a roof over the heads of the children, but was a charge imposed on mother's father for the roof over father's head. Of note to the conversation here, the court discussed the California Supreme Court decision in Davis v. Davis, in which the Supreme Court considered the effect of remarriage on an existing child support order. Basically, in Davis, the parties were married, divorced, got a child support order, remarried, and divorced again. After the parties divorced the second time, mother tried to make father pay child support for the 36 months from the time they were remarried to the time of the second child support order, and she did this via a writ of execution based on the first child support order. The trial court ruled that the remarriage terminated the first child support order, and the Supreme Court agreed with the trial court. The Supreme Court reasoned that termination of the order on remarriage was consistent with the objective of reestablishment of the family for the benefit of both the children and the parties. Also of note to the conversation here, the court discussed the Court of Appeals case in remarriage of Wilson and Bodine, in which the Court of Appeals applied the Davis ruling to a case in which the first child support order came from a parentage case and not a divorce. The order of events in that case was that the parties were living together, they had a child together, they split up. Mother got a child support order in a parentage case, aka a parentage case or a paternity case. The parties had another child together and later married. Of course, they were reconciled when that happened. A few years later, the parties separated and got divorced. The local DCSS got involved and asserted that father owed a very large amount of child support arrears based on the child support order mother got in the parentage case. The arrears included the time that mother and father were married to each other and living together. The trial court did not follow the decision in Davis discussed above because the original child support order came from a parentage case and not a divorce. The Court of Appeals reversed the decision of the trial court and relied on a well-reasoned decision from the South Dakota Supreme Court, Schaff v. Schaff, which had concluded no distinction should be drawn between the effect marriage had on a paternity decree versus a divorce decree of child support. The Court of Appeals ruled that even though the first child support order was terminated by the marriage of the parties, on remand, the trial court still had to determine if father satisfied his parental obligation after mother and father's post-marriage separation. The court noted not giving credit has the effect of discouraging attempts at reconciliations in which the living arrangements reunite the payer parent with the children. Taken to its logical conclusion, it means that a payer parent would be forced to bring an expensive legal proceeding as the entry fee to any attempt at reconciliation. And there's also the prospect that the payee parent will misconstrue the nature of the proceeding, which would have to occur at the very moment the parents were contemplating reconciliation. People generally do not like getting served with legal papers, particularly from someone with whom they are contemplating living under the same roof. In relationships that are psychologically fragile to begin with, forcing one side to run to court to effectuate a reconciliation is a rule that thwarts attempts of parents to reunite and provide children a single household. Now, not discussed in the cases, but as a practical matter, the safest thing to do when you reconcile is actually get support set to 0. But the court recognizes that that's not always a practical option. Notably, this decision by the Court of Appeals essentially makes it so that Family Code Section 2602 not only applies during the pendency of child support cases, but after judgment is entered in a child support case. But it's interesting because the court doesn't straight up say that reconciliation terminates the child support order in these situations. In a couple different places, the court says that the payer parent, in our scenario father, needs to show that he met his parental obligation of providing for the children during that reconciliation. So the take-home point of all of this is that when there's child support order, regardless of if it's a result of a divorce case or a parentage case, and regardless of if it's a temporary or a permanent order, when the parties reconcile and live together with the children, that child support order is essentially set to zero. If an action is later brought against the parent ordered to pay child support, that parent should be prepared to present evidence to the court that he satisfied his parental obligation by providing child support during the reconciliation. What do you want to do?
And the dad's name was named Noodle.
Okay, let me keep recording. That was one of my son's cameos. He's grown quite a bit since his previous cameos when I've recorded these videos. Anyway, thank you for tuning in. Again, this was not legal advice. You can check out the citations in the description below.
It was plain banana.
And please be sure to like the video. Baby, you're interrupting. Please stop.
Banana.
Yes, please stop. Be sure to like the video, subscribe, ding the bell so that you get notification of future videos that we upload. If you have any questions or comments, put them in the comments below. Any answers will not be legal advice. It's for educational purposes only. Those comments often provide for good discussion, and sometimes they find their way into an entire video unto themselves. So again, thank you for tuning in. We look forward to seeing you in the next video.